Hello, welcome to Reading the Law. On this first episode of Reading the Law, we dissect issues of labor law in Ghana, particularly the rights and duties of employers. Now we have Godwin Selassie Dapo, GSA in the house. Now my job is to read the law and he will explain. Now the goal is to ensure that you understand the law so you can comply. I am Newman Sedem and this is Make It Legal.
Make it legal.
You're welcome, counsel.
Thank
Long
you.
time.
Yeah, it's a pleasure to be here. I'm happy to see you too. So,
It's been a long time.
yes.
How was your weekend?
By God's grace, everything is fine.
Great.
I'm happy to be here.
I'm happy to be here too, It's been a show we've been looking up to, and today we happen to do this show, and, I'm sure that it'll be a great show having you here.
Thank you. Like we discussed before, this program is to ensure that our viewers and our subscribers are able to understand the law in a more relaxed environment where we get to read it and they will see it as we read it, and then we get to explain it and they will listen as we explain it. And the goal is to ensure, like you rightly said, that they should understand what the law says and be able to comply. So perfectly, I'm happy to be here. So let's go ahead straight away. You read the law and then I get to explain it. So at the end of the day, we have the subscribers in mind, our viewers in mind, and ensure that they understand what we are saying. So let's see how it goes.
Right, so counsel, let's quickly go into the Labor Act 2003, Act 651, Section 8, the rights of employer. Now, it says that subject to this act and any other enactment, the rights of an employer include the right to A, that is subsection A, to employ a worker, discipline, transfer, promote, and terminate the employment of the worker. And then the subsection B says that the employer will formulate policies, execute plans and programs to set targets. And then the C says that modify, that is the employer modifying, extend or cease operations. And then the D says that to determine the type of product to make or sell and the prices of its goods and services. So that is the section 8 of the Labor Act 2003, Act 651, the rights specifically of employer. Counsel. Yeah, so let's go into the first section, which is the employer will have to employ, discipline, transfer, promote, and terminate the employment of the worker. Right, so counsel, can you explain that to us?
Yes, why not? Perfectly so. So Section 8 of the Labor Act, that is a law that provides for everything pertaining to employers and employees and employment and all of that in Ghana. That is the Labor Act we're talking about. And the section you just read, is one of the sections that provide for the rights of the employers and their statute. So we have the employers' right under our statute, and then we also have the employers' right at common law. Common law is like a body of laws that regulate certain activities. When we talk about the rights of the employers, as you've just read, it comes in many forms. The first one talks about the employer's right to employ the worker, discipline, promote, and transfer. So that simply talks about the power the employer has to start the employment process. It is the employer that kickstarts the employer-employee relationship. If it does not employ, there will not be an employee, and there will not be an employer-employee relationship. And then he has the power to also promote, transfer, and discipline the employer. Many people might be wondering why, at the workplace, people get promoted or transferred to other departments. It is because the employer has the right to do that. Now, what it means is that you need to identify who your employer is, who has the power to actually transfer you from one organization or department to another, and who has the power to promote you. So that if you see that someone at the workplace has been promoted, but the person is not promoted by the organization that is employer, then there is a problem there. You see, that is where this law will come into view to sort of correct that problem that is existing at the workplace. Now, it also talks about the right of the employer to formulate policies, and also by those policies, put plans and programs in place to achieve set targets. That is entirely the employer's right. It is his right because he can do it if he wants to do it. He can also modify, extend, cease the operations of the organization. That is entirely at the employer's right to do. The last part on the list talks about the fact that the employer determines the type of product to be sold by the organization. If you are into cement production or manufacturing, it is purely at the employer's discretion to decide that we are selling the cement, or we are selling this type of cement, or we are selling that type of cement. It is his right. He decides it. You, the employee, does not have the power or the right to determine that. So, that is an explanation I can offer just to ensure that this law is simplified for everyone to understand.
Okay, so looking at point C, it says that the employer has to modify and or cease operation. So some of our viewers may not understand that point exactly. So you may want to explain that to us.
As well, I think it's good to explain it briefly. When we talk about modifications that can be done by the employer, we're referring to modifications that affect the operations of the company. The company has been selling, say, tomatoes, and all of a sudden you want to say you're going to sell maybe onions, right? Or the company has been selling maybe some building materials, and all of a sudden you say you're changing it to another product. It is within the right of the employer to say that he wants to sell this product or reduce the quantity of that product. That can be a way of modification. Then we also talk about extension. He can extend the services to include other services not initially provided by the same organization that he works with. Then he can stop certain services. He can say that the department in charge of, say, selling ABCD to the public, it is not giving me enough profit, therefore I want to stop. He has the right to stop producing, or the right to, terminate the operations of that department. So that is what we mean when we talk about the right of the employer to modify, cease, and extend some operations of the business.
Okay, so I believe counsel has made the explanation easy for all of us to understand. Now we are moving on to the next point, the next section, which is section 9, which says that which talks about the duties of employers. The employers have their duties in as much as they have their rights to do the aforementioned point. They also have their duties that they discharge. Right, so let's continue, and we are continuing with that. Now, it says that without prejudice to the provisions of this act and any other enactment for the time being in force, in any contract of employment or collective agreement, the duties of an employer include the duty to A. Provide work and appropriate raw materials, machinery, equipment, and tools. Now, the B says that pay the agreed remuneration at the time and place agreed on in the contract of employment or collective agreement, or by custom without any deduction except deduction permitted by law or agreed between the employer and the employee. Now, the C says that the employer will take all practicable steps to ensure that the worker is free from risk of personal injury or damage to his or her health during and in the course of the worker or the worker's employment, or while lawfully on the employer's premises. They also have to furnish the worker with a copy of the worker's contract of employment. G, and the G says that the employer has the duty to keep open the channel of communication of the workers, and they have to protect the interest of the workers. So all of these points that I've mentioned are the duties of an employer. Now, counsel will again have to, look into this point for us one after the other and then explain them to us for all of us to understand. Counsel, yeah, so these are the points made, which is under the duties of an employer.
Is there any particular you want me to explain?
Yes, definitely. There are some of them that I would want you to explain, and I'll start with the remuneration, because when you talk about remuneration in our country, it's very important to all of us. Now, if it says that the employer has the duty to pay the agreed remuneration at the time and place agreed on in the contract of employment or collective agreement, or by custom without any deduction except deduction permitted by law or agreed between the employer and the worker.
Yes, so let me explain that point. Now, every employer has rights, just like you said, as well as duties. And one of the duties they have, as recognized by the law, is the duty to pay remunerations. Remunerations here is a bit broad. It talks about, first of all, salary. It is the employer's duty to ensure that the employee is paid salary. And the law says that at the agreed time and agreed place. So if we say that in an employment contract, you will receive your salary at the end of every month. If the month ends, your salary has not come, the employer is in breach of his duty. Because the law says that he's supposed to pay it at the time agreed and at the place agreed. You can give him an account number for him to pay your salaries into. He's not supposed to go and pay it to a different account number and say that he has paid you. That will amount to a breach of duty. If he says that because he has paid it to that account number, he has paid you, you can actually have a claim against the employer for breaching the duty to pay the salary at the time agreed and at the place agreed. And then the law also says that the employer has to pay it without any unlawful deductions. There are deductions that are considered lawful and some are not considered lawful. So the employer has a right to only take out those deductions that are lawful. What are the deductions that are lawful in the law? We can talk about social security contributions. It is a lawful deduction. The employer is mandated by law to ensure that he deducts that amount of money from your salary and pay it to the social security trust fund. And then the employer is also entitled to deduct tax from your salary. As you earn income from employment, you're supposed to pay tax. So you pay personal income tax at the end of every month, and the employer is the one who has a duty to deduct that. But any other deduction that he does without agreeing with you is unlawful. So if you realize that your salary reduced contrary to what you were promised that you will take, you have a claim to report it to the employer to take steps to correct it. If he doesn't correct it, he's breached his duty and you can take him on that basis. I believe that clarifies the point there. I think the point I also emphasize before you ask question on the one that I should explain again is about the employer having a duty to give you a copy of your employment contract. And that is something the law is very particular about. It is mandatory for the employer to ensure that a copy of your employment contract is given to you when you are starting your work. So the employer cannot just sign a contract and keeps it with himself and refuse to give you a copy. The problem will be that when there is an issue that you're supposed to look at what the contract says and follow, you cannot look at it if you don't have a copy of the contract with you. So the law is quite clear that the employer has to give you a copy of your employment contract. If you don't have it, please ask your employer for a copy of your employment contract, because it is his duty to ensure that you are given a copy. And I think it's your right to have what someone has a duty to give you. You always want to try and use amicable ways of resolving the dispute. If he has denied you the right to have your employment contract, at least go find out why. If he still insists that he just doesn't want to give it to you, then you have a claim to challenge his refusal and says that no, it is your duty to ensure that I'm giving a copy. Why are you refusing to give it to me?
Right, Counsel, thank you for the explanation. Now, there are two of them that caught my attention, the A and the D. So I would want you to explain that to our viewers and all of us. Now, the A talks about the employer having the duty to provide work and appropriate raw materials, machinery, equipment, and tools. Now, when you go to the the D also is talking about developing the human resources by way of training and retaining of the workers. What these 2 points are saying, have different meanings, and so I would want you to highlight more, on that for us, Council.
You are right. So it is the employer's duty to provide the tools you use to work. If you work in a factory and you manufacture things, it is not your job to buy the equipment and the machines you need to work. It is the employer's duty. Again, the employer is the one who must make available the raw materials you need to process whatever product you are processing as a company. That is the duty of the employer. That's why when you work in an organization, it's not your duty to carry your own laptop and send to the workplace and use for the employer's work. No. The employer is supposed to provide the laptop that is necessary or required to use to do the work. If you work in a printing press and you print materials or you print books and all of that, and use laptop to edit the document you'll be printing, it is a duty of the employer to ensure that the laptop is available at work and the machines for printing and all of those equipment required for the work to be done is available. Now, you also spoke about the duty of the employer to ensure that the human resource base of the company is developed and also retain the workers where possible. So if people join your company as national service persons, it is your duty as an employer to ensure that they get trained on the job, and when they are trained and they develop good skills that they can be retained to do the work, you retain them in the company. That is something that the employer has a duty to do under the law. I think that is the explanation I will offer just to clarify those 2 points. They are very important points, and a lot of employers get to be sued for breach of duty in respect of some of these issues.
Right, so thank you, Council, for those explanations you've given. Now, let's look at the last but not least on here, point over here. We talked about, I'm sure it is of most interest to our viewers also, and so more reason I'm here highlighting on that. Now, it talks about protecting the interest of the workers. There are many instances where the employers, do not actually care about, some employers actually do not actually care about their workers, and some go by way of abusing them. What does the law say about those ones? What action can the employer or the employee take legally on in that regard? Talking about the age, which talks about the protecting the interest of the workers, which the employer has the duty of.
Yes, thank you, Sadam. I think you have a point there. That is a very important concern for a lot of employees. Now, just like you rightly read from the law, the employer has a duty to protect the interest of the workers. Now, the question to us is, what is the interest of the worker? Basically, every worker gets employed to get remuneration and to have opportunity to use his skills, right? So if for some reason at the workplace the employee is not getting the opportunity to use his skill, or the employer is going to take a decision that will affect the ability of the worker to use his skill at the workplace, or the employer is going to make certain decisions that will affect the ability of the worker to earn an income or to receive payment for work being done. Let's say, for instance, the employee is supposed to close at 5 p.m. every day, but the employer says that because of the volume of work we have in this department, you are going to stay till 8 p.m. or 9 p.m. before you close. Now, is that in the interest of the employee? Is the employer going to pay for that work? Remember, the law says clearly that the employer is under duty to ensure that he pays for any extra work of hours the employee puts into his work. So if the employer is refusing to pay for those extra work by insisting that you should continue to work for those extra hours or he will dismiss you, that's obviously against your interest. So the law is saying that it is the duty of the employer to ensure that the employee's interest, whatever it may be, is protected. The employees have interest, number one, if you are the employer who owns the company and the company has given jobs to the employees, and all of a sudden you are taking a decision, say, to reduce the operations of a particular department, and some employees will be affected. I mean, their interests are at stake. Another example could also be that you are transferring your interest in a company to another company. In other words, you are making another company take over your company. Would your employees be willing to be employees of that other company if you transfer your interest to that other company? So the interest of the employee is at stake there. So in all transactions and in all dealings by the employer, the law says that he has to consider the protection of the interest of the employee. He should not just get up and make a decision thinking that all that he cares about is to make profits and make gains for the business. But he has to be concerned also about how your interest as an employee in an organization is protected. And that is very, very important to emphasize.
Right. So thank you, Counsel, for that explanation. I think a lot of workers, are being abused by their employers. Mostly they are being abused by employers. I don't want to mention any companies over here.
Yeah.
But I'm sure, our viewers also know what exactly we are talking about. Right. So thank you for staying with us for all this while. Now, if you have any question regarding what we've said over here, kindly go into the comment section and leave your comment over there. We'll attend to you very quickly. Now, I'll urge you to continue watching the Make It Legal content here on the YouTube channel. Kindly, continue to share to other people, your friends, family, and other people, for them to watch this very educative program, Make It Legal. Thank you for watching, and please remember to subscribe to the Make It Legal channel. Thank you so much.
You thank me too.
Thank you, Counsel.
Thank you.
It's been a good day.
Yes, thank you.
Right, so this has been the episode 1 of Reading the Law. I am Newman Sedem, and this is Make It Legal.
Make it legal.